Good morning. James Doherty for the appellant, Marion Cheryl Beaver, who's present in the courtroom. May I reserve 3 minutes for rebuttal, please? Thank you. The purpose of a dependency is to, according to In re Becker, to determine the welfare of a child in his best interest.
Actually, this guy is completely wrong, and he knows it. If you look under RCW 13.34.030, you will find this section of law only defines an abandoned child. None of these children were abandoned. According to the first definition in the relevant section, a child must have been abandoned for a period of 3 months prior to the filing of a petition under RCW 13.34. This condition constitutes the legal basis for dependency. Consequently, any party is authorized to file the petition, as the child lacks an available adult guardian and is unable to initiate the petition independently, necessitating placement in shelter care.
There's also another principle of a dependency that its purpose is to ensure the safety of the child in reunification with the parent. Those are the underlying reasons for dependency.
Wrong answer. The word reunification does not exist under these laws. No instructions exist because there is no trial. These are all agreed orders. Parents have to want to give their juvenile delinquent to the state because they don't want to deal with their child anymore. Why would the laws say to deal with the child if they were talking about a child that was not out of control? There is no such thing as a contested dependency order. Dependent children used to be called a ward of the state, meaning they have no parents.
The lengthy decision of the Superior Court case, or Superior Court judge in this case, talked about a decision or a real party and interest concept, which is a concept. It is present in other forms of action, but it has absolutely no place in a dependency. It is completely irrelevant and has no basis in law, authority, or precedent to be considered. Washington Supreme Court in 2008, citing an Indiana Supreme Court case, stated, "A real party in interest is a person who is the true owner of the right to be enforced. He or she is the person entitled to the fruits of the action." A case involving a child is not to determine who gets money, who gets an easement, who gets an entitlement, who gets property, who gets an inheritance. It is to protect the child. It is the request, the prayer to a Superior Court judge to protect this child.
Well, even in considering a real party in interest, CR 17A, right? So we'll see CR 17A. It does allow for a party authorized by statute. And we have a statute that authorizes any party to file a dependency petition, correct?
That is absolutely correct, yes. And so I represent the appellant. They are the parents. They were relatives and interested parties, longtime caregivers. They were any party, and they had information which is unrebutted. This is not from summary judgment. This is from a motion to dismiss, essentially a 12B6 motion to dismiss. So the party in this case, Cheryl Beaver, had information, the passing of the mother through a drug overdose, as well as a father who had prematurely left a drug treatment facility and was living on the streets of South Seattle with another girlfriend starting to use drug.
I'm not sure it matters, to be honest, whether they have or don't have information. The legislature said any person. They're any person, right?
I agree.
Okay, so maybe focus on what do we do with this, I won't call it a certification requirement, but the determination requirement from the probation officer. What do we do with that?
Well, and as the court is aware, King County does not do that. That is unrebutted. King County wisely has chosen not to do that. No one does that. There is a docket every Friday morning, probably usually into
Does that equate to that it's not possible for them to do that? I mean, certainly was there anything that prohibited the court from saying, I'm going to continue this hearing, I'm going to refer this petition to the probation officer because I want them to review it under the statute where in fact they have an obligation, a duty to review it?
That's a suggestion that would be something that would have been a viable, sensible option. That was not done, that was not explored by Superior Court. The probation officer could have done that. That would have been a sensible remedy to preserve the case, to move forward on this case. That has never happened. And
So whose responsibility is it to get that determination, if it's possible?
if it is possible, certainly the petitioner would obtain that review from a probation officer to determine if there is any
Does
basis.
the language of the statute where it talks about that say the petitioner shall obtain this, or does it say it shall be done?
Let me not misspeak.
Right under RCW 133404 subsection 2, except where the department is the petitioner.
Yes, here it is. As I did locate it, sorry.
Right.
Except where the department is the petitioners, these officers, it doesn't really say any party.
That's what I'm saying. What I'm
Yes.
saying is, does the statute explicitly say that it is the petitioner's burden to do that prior to filing?
It does not.
Is there, I mean, is there any gatekeeping function for anybody to do it? I mean, you, Mr. Doherty, could say, I don't know if you have children. Let's assume you have children. Set aside the facts of the case. Can any person, I not only want you to have your kids go into dependency, but now I'm going to ask for discovery, and I'm going to get all the information, I want all your financials, Mr. Doherty.
Not even DCYF can remove a child from an actual person using a dependency petition, and the wording in the law proves it. Somebody get these judges out of here. They are horrible actors and belong in prison. They have allowed CPS to destroy hundreds of families with zero laws to do it. As you can see, they are only permitted to take a child into custody not from a person's custody because the child is abandoned, remember? They are applying laws for abandoned juveniles. They have to do this in order to get federal funding under the Adoption and Safe Families Act of 1997. The judges in the Superior Court always tell the parents to shut up, because CPS is alleging the parents are not there.
So what is there a check on that of any kind?
The check is the rules of civil procedure. And so the check would be, are there sufficient allegations within the petition to establish whether a child is dependent? So merely coming in with a best interest discussion or a we think we could do better discussion doesn't match that. And the gatekeeper is the Superior Court judge. And the gatekeeper under Rule 56 for summary judgment or 12b-6 can make that determination that they are in fact, these allegations are not sufficient.
But then, when does the judge exercise that gatekeeping role? Is it at a 12b? Is it a 12c? Is it a Rule 56? And I'm really not talking about the facts here at all, right? These are all hypotheticals, all right? These are not the facts here. Just when do they do that? And does that mean that whoever, you, Mr. Doherty, are now the defendant in my petition to put your kids in dependency, now you have to go get counsel, and you have to respond to discovery, and you're spending $50,000 before you know it.
Well, it's an extraordinary action. It is. Dependencies are a very powerful action, but they are powerful for a reason. And that's because the Washington Supreme Court and the Washington legislature have determined children need to be protected. And the reason that it is written so broadly, am I out of time?
You could just briefly complete your sentence and
I-
come
thank
back
you.
on rebuttal.
The reason it is because the children need to be protected. And the gatekeeper is the judge. If there are insufficient allegations, a motion for summary judgment or a 12b-6 or 12b-C is the remedy. It is because the extraordinary need to protect children in our society and in our community, that is why that is present. That is why there is such breadth to it.
Thank you, counsel.
May it please the,
You can lower the mic.
may it please the court, my name is Taylor Shootcraft, and I'm a Rule 9 intern here with my supervising attorney, Willa Osborne, and I represent the respondent father in this case. The trial court was correct when it said that RCW 1334-040 was not created as a weapon to pit family members against each other. And
Doesn't
this-
the language of the statute literally say any party can file a dependency petition?
It does.
So,
Despite the language of the, and in this case, the petitioner did file a petition, and it was dismissed. And this court would ask that you affirm the dismissal.
but the
There's really-
reason it was dismissed is they're saying they're not a party in interest, but the statute gives them a right. Any person can file a dependency petition. So I'm trying to understand how the court correctly applied the law, saying it's dismissed because they're not a party in interest, when the statute legislature gave any person the ability to do this.
Yes, Your Honor. The court did dismiss on that ground, but appeals court can affirm on any grounds that the record supports, and there were multiple other grounds on
Let's
which.
talk about the other grounds then.
In terms of the multiple other grounds that are in our briefing, the first is that this child doesn't meet the definition of a dependent child,
Isn't that a 12B issue?
which was raised in terms of asking for judgment on the pleadings.
And not addressed. It was dismissed without addressing that motion.
And we would, the father would ask that it be considered here, because the appeals court can dismiss on any grounds that the record supports.
Let's go back. So are you conceding that the court dismissed it on the other grounds improperly?
I don't think we're conceding. I think what we're stating is that there are better grounds that the court probably could have dismissed it on.
So you're not conceding the any person issue, is that right?
I'm sorry?
Well, the real party in interest, if the statute says any person, and we know that the petitioner is a person,
Yeah.
is that enough?
The statute says that any person can file a petition, and in this case, they did file a petition.
Okay. Do we have to address a real party in interest issue, or has the legislature told us that's not sufficient, or that's not necessary, so long as you have someone who's any person?
The legislator says that it's not necessary to address someone filing a petition. Anybody can do
So
that.
the court was wrong when it said you're not a real party in interest.
The court seemed to think that CR 17 wasn't clear on whether they could also prosecute the case in addition to filing.
CR 17 talks about authored by statute, and there's a statute that authorizes.
Authorized to prosecute, to sue, which, again, we can see that there were better reasons.
So what's your best argument?
That even if taken every fact in that petition as true, it doesn't establish that this child was dependent.
So you think you can win on 12C grounds?
Yes,
We have
Your
to
Honor.
accept all of the allegations of the complaint as true. We have to view the allegations liberally. There's a lot in that declaration or that petition to establish dependency. So what specifically is missing?
What's missing is a causal link, a nexus between the father's substance abuse and harm to the child. There's no fact in the petition that establishes that this child has suffered the requisite risk of danger to her health, welfare, or safety that either a prong B or C dependency requires. They concede in their briefing that there's been no abuse. If we take the facts in the petition, what we have is a father who struggles with substance abuse, who let his child remain in the care of a suitable adult where she had been living while he went to address his sobriety. That's the decision we would hope a parent struggling with substance abuse would take, that they would ensure the safety and stability of their child while they did what they had to do to get well. That's what this father has done.
Shouldn't the petitioner have had their day in court to be able to address the merits of that argument?
Your Honor,
They didn't even get to argue that.
they didn't get to argue it because it didn't get to the merits because they didn't follow the procedure, the required procedures.
Okay, let's talk about the required procedure then. It sounds like you're saying you're not conceding that it was properly dismissed because they didn't have a probation officer review it.
Right.
One, where in the statute does it say that the petitioner has the burden to do this? Two, the petitioner submitted evidence that they talked to that department. They say, hey, we don't do that. Yet that was held against them that they didn't do something that King County doesn't do. Three, Why didn't the judge say, I'm going to continue this here and I'm going to refer this to have that review done?
Absolutely. I can't speak as to why the judge didn't, but what I can say is that it does say that where it's possible, a probation officer shall.
That's right, but where is it the burden on the petitioner that it didn't happen, and that's why the petitioner doesn't get to have their motion heard on the merits?
In the mandatory petition form, it requires that the petitioner give
Is
it
the
to the
form the
probationer
law?
to sign. The form is not the law, but it says that this shall happen, and it didn't
Is
happen.
there a local rule that says that?
No.
Okay, so then what's the authority for the court to say you're procedurally barred because you did do this, despite the fact you've given evidence to me that, by the way, we don't do it? I mean, how is that even fair?
Where is it in the form?
It's in the mandatory statutory form. It's in our briefing on page 25.
Okay, I have the form. You're telling me that there's a box that has to be checked here and it wasn't checked?
There's a certification. Yes, there is. It's in.
Well, the certification says, I declare under penalty of perjury under the laws of Washington that the foregoing representations are true and correct. Is there another certification?
There is, and in our briefing on page 25, we provide the court with a screenshot of it.
Okay, and I'm sorry to interrupt your question, Judge Cooper.
I was just saying, so why didn't the court say this wasn't done, we're going to continue this hearing, we're going to refer this to probation officer, despite the fact in the email they say, what is this? Oh, we don't do that. Other counties do that, but we don't do that, and say, well, I'm going to refer this for having to do that.
Yes, Your Honor. In the email, the question of, is it possible for you to do this? This is admittedly an unusual case. And so it's not the practice. That doesn't mean that it wouldn't be possible. If we-
Exactly. So then how is it the court can say that I'm dismissing this because you didn't do it?
The court dismissed because Section 2 of the law wasn't filed, but independent of that, the appeals court can appeal on multiple grounds. And so there's also other grounds that they could have affirmed on.
Can I go back to one of those other grounds that you were talking about before that you think from what I understand, one of the arguments you want us to consider is the 12C argument and decide it on the merits. And then you point to that there's no causal link between the bad behavior and effect. And again, like Judge Feldman said, I mean, when we have that kind of motion, we have to assume everything in there is true. I have no idea what's true. I don't know these people, right? I don't know what's going on, but we have to assume it. And one of the allegations, and this is at CP4, is that HW is at risk because she's staying with a person the family doesn't know. They've never been in the house. They don't know the surroundings. But they are aware that there's a shooting involved and that HW was there at the time on information belief. So we're taking that. And they're also concerned about unknown people having access to HW and maybe at risk because of that. Doesn't have a room, sleeps at the end of the bed. I mean, I'm not going to go on and on and on. But why isn't that, and then that's after a description of all the things that may have been going on. I'm sorry, this is a long question, but why isn't that enough of a causal link?
Sure. There's a couple things Your Honor said. The fact that they don't know the person that she's staying with does not establish the requisite require of danger.
But there's other things they said.
The fact that she's sleeping on the edge of a bed does not establish the requisite requirement of danger. The petition contains one alleged vague allegation of a shooting that came to the family's attention that happened 4 to 5 months prior to it being filed that allegedly involved the father and an unidentified adult son, who it doesn't say that she was present for that shooting or that her caregiver or her even knew about it.
Yeah, but then there are other allegations about the deceased mother being also concerned about her living arrangement. I mean, I'm not trying to pile up. This is the point. We don't see witnesses. We don't take testimony. But we know what the trial judge is supposed to do, and they didn't do it here. Why isn't that a reason enough to send it back?
And again, it's because the court can affirm on any grounds the record supports. The petition is in the record. Every fact in the petition, if you weigh it to the standard of a dependent child, that there must be evidence of serious disregard of consequences of such magnitude as to constitute clear and present danger to the child's health, welfare, and safety. Even assuming every fact in that petition is true, they don't meet that standard.
Thank you, ma'am.
Thank you, counsel.
Thank you. To very succinctly respond, one of the issues that was brought up is there was a citation to RCW 2644015, and this goes to the causal link. Within the respondent's brief, there was a partial quote of that, which seemed quite peculiar. And it goes on to describe what can be considered, and under that it says, when considering whether clear and present danger exists, evidence of a parent's substance abuse as a contributing factor, negligent treatment or maltreatment shall be given great weight. And part of the determination is not, as one might see in a criminal action or in a collision of a vehicle, is a direct nexus. It is a pattern of behavior and an ability to care for that child. Is there a parent that is capable of caring for that child? The respondent in this case, through the history of all of his children, which I think is relevant, including the termination of in Ray KW, his child, which made a finding of his unfitness. And after his failure to complete treatment, contrary to the representations that this was a parent that was addressing his sobriety, the opposite is true. In fact, that's what an inference might be drawn that might be the reason this precipitated this, was because the family gave him a chance. He left jail after being in jail for 6 months. They thought, he's sober. Let's give him HW. Let's give him a chance. He responded by relapsing. Then after just a few months of theoretically having some care of this child, transferring this care to some other past girlfriend, going into treatment, and then exiting earlier. That directly lines into the assessment and the type of evaluation that the legislature was asking for, is whether there is evidence of a parent's substance abuse as a contributing factor to negligent treatment or maltreatment.
So taken as true, and the petition is suggesting that he had an addiction issue, he was trying to do it, but he left early, which means he didn't successfully complete treatment, and there's a concern.
It was, furthermore, there was evidence that he had relapsed and was actively using crack cocaine and was on essentially in the streets of South Seattle and was engaged in the same behavior. And there was evidence of that was presented at the shelter care hearing, although that is not in the record.
So on page 25, as your opposing counsel noted, there's a Roman numeral 4, reasonable justification. Have you seen that? The certification requirement.
Yes.
And on the document, which was filled out, it ends with Roman 3. Why? Do you know why that is?
They're two separate documents. I believe they're two separate documents. And so there are
You can briefly answer.
standard forms for King County, state standard forms.
Right.
And so that is the petition, and I don't have 100% perfect memory, but I believe that's the King County petition.
So the King County form doesn't include Roman 4.
I don't want to misspeak, so I can't from my memory say.
Thank you, counsel.
Thank you.
Thank you.
All right, matters are taken under advisement. We are in recess.
All rise.